Okay, can everyone hear me? Give me a thumbs up, somebody. I was having audio difficulties the other day. All right, yeah, here we go. Well, welcome, Homecoming 2024, yes.
Yes.
Woo! We've had an exciting morning this morning, baseball, Colt, and now we're digging into justice. Let's see.
That's right.
First of all, like Julie said, get your tickets on sale now for the Cowboy Lounge. And we want to see you at the 5K. And backed by popular demand, burrito Brar will be back at the Kennedy Gallery. So come on down at 9 o'clock, get yourself a burrito, enjoy some art before the parade. So we've got Ruth Mariampolski up next. Ruth is our campus Title IX coordinator, an attorney licensed to practice in New York. Oh my, so look out, New York. And a person who enjoys discussing all kinds of legal topics. This presentation is a reprise of one given in 2022. So she's going to tell us about all kinds of new stuff. So let's learn how to read a Supreme Court case. Go for it, Ruth.
Okay, let me just quickly introduce my presentation and give a little bit of background. Essentially, reading legal documents is as much a skill as any other form of academic reading. And there's a lot of unique vocabulary and terms that are used that sometimes people who are not trained as attorneys, they just don't recognize what the vocabulary means. When it comes to Supreme Court cases, there's more interest in reading them now than ever before. So the goal of this training is to give a reader some of the tools to kind of understand what they're reading or feel familiar with the particular traditions of legal writing. Okay, I'm going to share my screen and begin. Okay. All right, everyone. Okay, so it is 11 on the dot. All right, I'm going to jump in. Okay, the first question or first thing I want to address is, where do I even find Supreme Court opinions to read? The first area is there's bound volumes found in many large academic and public libraries. They have this very distinctive look that you've seen in the background in many legal shows, this tan binding with the red stripe and the black stripe. There's also paid legal research databases. The two most well-known are called LexisNexis and Westlaw. There's free legal research databases, of which two very prominent and reputable ones is Cornell Law School Legal Information Institute and oye.org. And of course, you can also go to the Supreme Court's own website, supremecourt.gov. And if you're ever interested in exploring Lexis, the library has a subscription for employee use, I suppose students as well. Okay, so the first question you're going to ask when you're looking at a Supreme Court opinion is, what version am I looking at? So there's three flavors, as I phrased it: slip opinion, unofficial, and official. Slip opinion traditionally was a pamphlet published to distribute the decision to the public. But the modern version is being published on the Supreme Court Gov website. They no longer hand out these like slips of paper, as they were called. They do it online. The unofficial reporter is called the Supreme Court Reporter, and it has a specific form of citation, which you can see there, a number, the letters SUPCT, a second number, and the year. I'll explain what those numbers mean, what the citation format means, but the most important element is, if you see SUPCT in the center, you're looking at the unofficial reporter, which I think is very non-obvious because it looks like, hey, this is the Supreme Court. The official reporter is called the United States Reporter, and the citation looks like a set of numbers, the letters US, and a second number and the year. The this is the way an official reporter citation looks. If you are looking at a citation that looks like this, you are looking at the most official, most current, most final version. The difference between the versions, usually the difference is very minor. But if the official reporter is available, it's best to read it and refer to it. So what happens is the slip opinion comes out fastest, then the unofficial reporter comes out second fastest, and the United States reporter is the last to be published. So the reason why we sometimes see the slip opinions and the Supreme Court reporter is because they come to press faster. But when we're thinking about the three different versions, although in most cases we would describe them as very similar, every now and then there's a difference that's small but significant. And this is a very famous particular situation. A 1928 slip opinion contained a typo in which the word properly was wrongly written as property. The wrong version has been cited in 14 cases and in one argument in front of the Supreme Court. So don't be that person misquoting the Supreme Court to the Supreme Court, but that is a rare scenario, but it's the reason why we always look at the official version if it's available. And then sometimes the versions are actually different. It comes as a great surprise to many people that until 2015, justices were sometimes known to change their conclusions between versions without announcing any change. Today, changes are announced, which I think is a great improvement. Yes, in the past, if you're looking at older material, you might have differences between the versions that are significant. So next, we're going to launch into what's the anatomy of a decision? What are the parts of the decision? So the first thing you'll see at the top of the page is called the syllabus. The syllabus is basically a summary, and it's written by the judge's clerk. It's not written by the justice. It cannot be cited, and there's a disclaimer on it saying this syllabus is no part of the opinion. But it's usually very helpful to understand the general thrust of what the case is going to be about. The majority opinion starts at the byline. The byline is phrased as Justice so-and-so, I've named Justice Kennedy. Justice Kennedy delivered the opinion of the court. Under the byline, basically they'll begin with the procedural history. They will state who the lower court was, because not all, but the majority of Supreme Court cases are on appeal. There's a very small segment of cases that can go directly to the Supreme Court. So first, they'll usually talk about the procedural history. The trial court said this, the Court of Appeals said that, this came to us, now we're here. And there are certain cases in which the procedural history is immensely complicated. It bounces up and down between courts, arguing about this and that. So the procedural history can sometimes be a very important element. The next section will be called is the body text or the reasoning. It's the main content of the decision. It's the parts that are usually quoted. It's the vast majority of the text. And that's like the bulk of it is the reasoning. The last element is the disposition. It's a really good legal term. Another favored legal word, not used very much by non-lawyers, is the word dispositive. A fact that's dispositive leads to a disposition. It leads to a result. Anyway, the disposition is what the court orders to happen next. It isn't usually in its own section, but it's the last thing that's discussed. And at the very end, there's the phrase, "It is so ordered." This declaration, as I state, is where the majority opinion ends. Following the majority opinion, there may be other opinions. If there are other opinions, they are presented in the following order. First, the majority, then the concurrences, and finally the dissents. Each of these words have different meanings to lawyers than they might have to the general public. So the majority opinion is the binding opinion and reasoning. One justice writes for the majority and is named as the author. The concurring opinions are justices who agree with the result, but for a different reason, may write a concurring opinion, also called a concurrence. And I've highlighted here that in general speech, when people say I concur, they use it to mean I agree, oftentimes to mean I agree completely. But in legal terminology, it means something very different. It means the right conclusion, but the wrong reasoning. Finally, we have dissenting opinion or opinions. Justices who disagree with the conclusion and the reasoning may write a dissent explaining why. Some dissents become very influential over time and can be cited to argue for changes in the law. That is why dissenting justices write the dissents, in the thought that future readers or future analyzers may adopt the dissenting reason in the future. Next. And remember I mentioned disposition. Disposition is what happens next. So there's three most common: affirmed, reversed, and remanded. Affirmed means we agree with the lower court and confirm that the decision was correct. Reversed means we reject the opinion of the lower court and we rule the opposite. Remanded means we send the matter back to the lower court to apply a new rule that we established. Oftentimes this means applying the new rule to a set of facts or to conduct a new trial. It's an important distinction that the Supreme Court cannot change the factual findings of a jury or a bench trial judge, who are called the fact finders. They can only state the correct legal principles that should be applied. If the original reason, this is more of a discussion, if the original reasoning is found faulty, sometimes it's not enough to simply reverse the decision if the fact finder used wrong legal principles to evaluate the evidence. Instead, the case must be reconsidered from the ground up, so it must go back for a do-over, which is a new trial. Note that a new trial does not mean a different result. If the jury, applying the new stated principles, finds the same result, then that will stand. The Supreme Court doesn't determine a result in those cases. It only dictates what legal principles should be followed. Finally, we have the category of per curiam decisions. Sometimes instead of an author's name, you'll see the words per curiam. Per curiam means by the court. A per curiam decision has no author identified. They're usually less significant matters, but not always. Sometimes used in highly controversial matters. Bush v. Gore, the case of the Florida election recount, is probably the most well-known per curiam opinion. Note that per curiam, even though it means by the court, does not mean unanimous. There is a concurrence and 5 dissents in Bush v. Gore. All right. So now that we know what are the different elements of the case, how to understand them, I'm gonna talk about legal citation. When you're looking at a legal citation, it's full of specialized information. You see the number, remember I noted US is the name of the reporter. The number that comes before the reporter is the volume number, even though the vast majority, today, cases are reviewed online using internet-based search databases of different kinds. We still pretend like people use the books, which they don't actually. But so the first number tells you the bound volume number, then the reporter, then the first page where the decision begins within the volume is the number. And then finally, we have what we call the pinpoint citation or the pin cite. And lastly, the year. In legal writing, any statement of fact in law should be supported by a citation. Citing entire large sources is not correct. The pinpoint citation or pin cite refers to the exact page within the matter being cited where the proposition is supported. So, for example, like I'm just going to give general example. So the proposition is that the sky is blue. You cannot just take a physics textbook and cite the whole thing. You have to say on such and such page, the physics textbook says the sky is blue. There is something called citing generally, or passim. We're not going to worry about that right now. It can be a very bad habit for people to cite things generally. More on legal citation. Hey, if you're a giant nerd and you're really wanting to know more about legal citation, the place to look is the Blue Book. Here's my copy. Note how thick it is. It's the legal citation manual. And in contrast to some other kinds of citation manuals, it doesn't offer general guidance, and it is not a style manual. It does not tell you the best word choice or stylistic elements of writing. It is solely 400 pages of extremely specific instructions in tiny type for every citation situation that you can imagine, including situations that are incredibly rare. For example, it has specific instructions on how to cite the Constitution of Austria. Now, that's not something that happens frequently, that you need to cite the Constitution of Austria, but if you need to, you're going to go right to the Blue Book, and it's microscopic type on a variety of topics. And you can also use the Blue Book. The reason why lawyers always generally have one in their office is that if you see a citation you don't recognize, you should be able to go to the Blue Book and see what it means. So I've given an example here. I'm looking at a document cited as the Rocky Mountain Min El Inst. I don't know what that means. The Blue Book will tell me it's the Rocky Mountain Mineral Law Institute. Then, yeah, I guess I'm really zipping through this material. But where is like the most accessible and thorough information about cases? I would say that it's at oye.org. Now, why is it called oye? Because the Supreme Court begins its session by calling out oye, oye, which is in French, it means listen or hear, hear. And I like to joke that the Supreme Court is so old-fashioned that Latin's not good enough. They need to go to Norman French to show that they are the oldest, most old-fashioned organization. So Oye is French, and basically this website collects all kinds of background information for Supreme Court cases. You can listen to the recordings of oral arguments. You can see information, much more detailed information about the lower court rulings. You can learn the names of the lawyers who participated. You can find out when individual actions happened. And I would say for the non-lawyer, the thing that's very, very useful on Oye is it provides a clear statement of what question or questions the Supreme Court sought to answer. And it's important to understand that the Supreme Court does not give advisory opinions. That is to say, they don't give their opinion about events that have not happened. They only give rulings on specific questions about events that have already happened, and they have to agree in advance what questions they'll hear. So the specific questions are found in the grant of writ of certiorari, historical name for an application for appeal. Now we're back to Latin, away from Norman French. It has the same Latin root as the word certified, and sometimes people call the questions that the Supreme Court plans to answer as the certified questions. But bearing in mind that the Supreme Court will, or at least should, only comment on the specific questions they were asked to answer. They're not supposed to, when a court makes offhand comments about matters that are not before it, that they're not actually evaluating, the term for that is dicta. Dicta, as I would translate it, it's a Latin term, obviously connected to the word dictation. I call it stuff people say, right? It's stuff that people said. It has very little legal significance, and a reader can get tripped up seeing that there's statements or commentaries that are more offhand or collateral to the issue. They can be very misleading because if lawyers engage or judges engage in a lot of dicta, it mixes up and scrambles the explanation of what's going on. So always look to the certified questions to understand what kind of information you should expect. When you see something that doesn't match the certified question, know that it's dicta. You're not supposed to do it. You're not supposed to make commentaries or editorialize. You're supposed to address the legal issue in front of you, but you know, sometimes judges can't resist. They need to make comments. That is pretty much the whole of what I wanted to share. I wanted to, here, let me see if I can bring this up as a, let me see if I can, sorry, can't even get behind this because it's in the wrong place. Let me see if I can bring up a printed version. There's some sort of famous ones. So no, anyways, you can like look up different, you can look up different like print volumes, and we do have Supreme Court volumes in the Donnelly Library. A reference librarian can direct you correctly. I think they're on the second floor. I'm trying to remember where I've seen them. But anyway, the volumes are kind of interesting to page through. The Supreme Court has a very busy, usually, catalog of matters that they're hearing, and only a few of them are ever really make the news or are become culturally significant. A lot of opinions have to do with issues of criminal law and evidence for trials, and maybe don't have a lot of appeal past a select group of legal people who are interested in those subjects. But then, of course, some Supreme Court opinions are extremely socially significant for our entire country. So my goal is to give you the tool that if you're looking at an opinion, you understand the parts of what you're reading. It's not unusual for people to sort of become confused and not understand that they're reading a dissent, especially if they see something quoted in another publication. And so they may become misled because they don't understand the segments of what they're reading. I want to, let's see. I'm gonna stop the share of my PowerPoint and show you an example of something you might see on Oyez, and reshare the Oyez screen. Here we are. I picked one at random. It was literally at the top of Oyez. So over here, we see the name of the case. Here, petitioner is the person who asked for the appeal. It doesn't mean who is the original plaintiff in the original lawsuit. It means who asked for the appeal. In this case, it appears that it was a medical center. And the respondent, which is the other party who didn't ask for the appeal, looks like they are an individual identified as the Secretary of Health and Human Services, presumably for the state where this occurred. So then you'll see docket number and decided by. This decision hasn't been issued yet. That's why it says case pending. They will tell you who the lower court was. Court of Appeals for the District of Columbia, that's the DC Circuit. The DC Circuit is famous for processing cases really quickly. They call it the rocket docket. No citation has been published. That means there's no slip opinion. There's no decision of any kind. And the discussion is pending. The certiorari was granted. It will give a summary of the facts of the case. And here, this is what I find very helpful for people. What was the certified question? And the certified question in this was solely, does the phrase entitled to benefits include all who meet basic program criteria, whether or not they actually receive benefits? As we know, sometimes when individuals are entitled to benefits, they never receive them because they don't apply for them. So the question here is, when saying something about those who are entitled to benefits, what does that mean exactly? And the Supreme Court decided to hear oral argument about this subject. It tells you how to cite this page, and what the case name will look like. And this is the Blue Book citation format. I wouldn't worry about all the ins and outs of that, but as you know, they will always say when was the last time it was accessed, i.e. today. So that's a good example of a case that's waiting for, let me see if I can scroll through and find one that they has actually been argued. Oh, sometimes they have. Let me go to a different year's term. So you can see, you can search by term, you can sort by name, you can view by all sorts of different. So here's a good one that has all been completed. So Atchison Hotels, petitioner, respondent was a private individual, currently named Deborah Lawfer. The docket number for the case, that's like the case number. Where was it heard? In the United States Court of Appeals for the First Circuit. The citation format shows you that the official citation has not yet been established. Who were the advocates? So this person argued for the petitioner, and this person argued for the respondent. And here's another really fun category. This person, Erica Ross, she argued for the United States as amicus curiae, supporting neither party. What that means is amicus curiae is as friend of the court. Okay, sometimes advocates can submit their own briefs and sometimes oral arguments as friend of the court. And it means they're not a person whose case is before the court, but they have something to say about it. And here you can see, you can look at you can listen to the oral argument, which was held on October 4th of last year. And then here you can see the categories of opinion. The syllabus, you know what that is, that's the summary. The opinion of the court, it was written by Justice Barrett. There was a concurring opinion by Thomas. We know that means he agreed with the conclusion, but not the reasoning. And there was a second concurring opinion from Jackson, which means that two different people agreed with the conclusion, but had two different reasons for disagreeing with the rationale. And this question has to do with the ADA and testers scenarios. You can kind of see here, this is a person who essentially goes around and sues different organizations. They call them a prolific litigant. They sue different organizations about accessibility services under the Americans with Disabilities Act. The initial lawsuit found that Laufer lacked standing. Remember, only people who are directly affected can normally petition for a Supreme Court review. Lacking standing means you have no position from which to sue. Because they suffered no injury and had not visited the hotel. This kind of goes to the whole concept of that they don't answer hypothetical questions. So this is kind of the district court, that's the lowest court, the trial court, they found that Laufer lacked standing. The Court of Appeals disagreed. They said Laufer had intent to book a room, or their lack of intent to book a room did not negate the fact that the hotel wasn't compliant. Now the Supreme Court was asked to review that question again. Who was right? District Court, Court of Appeals. Does a tester have Article 3 standing to challenge a failure to provide disability services, accessibility on its website, even if a person had no plans to visit the hotel? So that's interesting. Then down here, they do show actual pictures of what the justices look like, which I find a little bit amusing. I don't know, doesn't seem very pertinent, but that is what they do here on OIA. You can see that this is a very in-depth wealth of information, and OIA even links to this is the Cornell Legal Information Institute. They link right to it because it's a helpful resource for lay people and citizens in the United States to understand more about their justice system. So I see some chats. Oh, yes. Thank you, Gina. It is on the second floor. And I think that it's easy to be intimidated by the sort of historical systems and hidebound traditions and bizarre vocabulary. But at the end of the day, you should know how to read a case. As a citizen, what we see reported in the media is often very inaccurate from a lawyer's point of view. So it's best to go to the source and read what the justices said rather than rely on media sources that are very often inaccurate. When you want to know what's going on with the case, go to the source, dive in. If you have trouble reading it or you have trouble understanding what they're talking about, there's lots of tools to help you. And sometimes you will hear in the media about some oral argument, something unusual happening, right? Different things. As an example, Justice Thomas rarely speaks in oral argument. He doesn't usually ask questions. So sometimes when Justice Thomas asks a question in oral argument, it literally makes the news. Now you may want to hear, what was his question? How did it come up? What was the context? You can go right here and listen to the oral argument and hear the question for yourself. The oral arguments are recorded. I don't believe that they're normally transcribed, but it may take a period of time, or you may be able to obtain a transcript. Because otherwise OIA would be not fully accessible. So yeah, that is pretty much my presentation. If anybody has questions or would like to share their own experiences of reading, what they got out of it, or maybe didn't get out of it, I'd love to hear them. I think that sometimes even as academics with lots of experience in our own fields, it's intimidating to read the formal documents from other fields because there's academic traditions in every field. Sometimes as well, it's very interesting to read about the advocates and what their backgrounds are. That can be quite insightful at times. Yeah, it's a great resource. I encourage everyone to use it. I hope that my presentation has helped people understand the anatomy, so to speak, of these cases and what the traditions of formatting are, really, more than anything else. And thank you very much for joining me. I hope that you all have a great day. If there's any questions, I'd be happy to hear them.
Oh, thank you. I put in I put in some chat about the website Puppy Justice, where the dogs, it's really good.
Oh, awesome.
It's amazing. It's amazing.
I'm
a
just
setting with dogs, and it's the voices. And Ruth Bader Ginsburg is this little one with the pearl necklace. And it's real voices of how to argument and how they argue.
That is very funny and also sort of welcoming. It kind of takes some of the intimidation factor out.
Yeah.
I love that. I love the concept. I've never seen it before, but thank you for sharing on that.
And I'm a graduate assistant in political science with political science, and I really am leaning towards political philosophy. And so I lived in DC for a little bit, so I'm kind of have to what goes on.
Absorb it. by osmosis.
All right, well, I hope to, eventually, I was thinking about getting a master's in, your department of, criminal law, but
Well,
I'm,
was a returner to law school. I always say it's never too late. You should follow your inclinations in that regard. And I will also add that certainly in my law school, some of the older and returning students were some of the most successful in my law school because they really knew why they were there. So that is great. And I love that everybody's, just kind of interested. The Supreme Court has a lot of influence on our society and the laws that can be passed. So I want to make sure that people know that there are resources that are more welcoming to the layperson, and that these are all out there and available and free. They give access to justice. Access to justice includes access to comprehending what happened in the courtroom. I'm totally going to check out this puppy justice because I bet it's going to be hilarious.
good. It's good. And then last
Um,
semester, I did a practicum with the criminal defense lawyer here in town. So
mhm.
I'm kind of in it. I'm kind of in it. But
Which is
anyway,
wonderful.
but thank you. And now that I'm glad to meet you, and thank you.
Thank you all for participating and joining me, and thank you for coming to my HU talk.
Thank you, Ruth. Anybody
All
else?
righty.
Questions? Is that, we good? All right.
I think that's everything that was in the chat.
Wonderful. Okay. And thanks for everybody for showing up. And next up, we're going to have, well, let's see. Oh my goodness. We're going with after lunch, Amanda Evans, and asking
Oh,
for help will change your life. Very
awesome.
true. All right.
Thank you all. I need to unshare. Hang on. Oh, Lord. How do I always manage to confuse myself? There we are. Stop sharing. Okay.